Good afternoon. This is a short presentation on the optional question for the business liability exam. If you remember, I previously went through a compulsory question which is available on YouTube and Moodle, and I'm just going to quickly go through the optional question. So the key point to remember here is that all you have to do if you choose is obviously the compulsory question everybody has to do, and this is the extra optional question that you might want to do if it's a question that you feel you've got enough knowledge on. Later on, when we come back from Easter, I will go through the other optional question, but it's best if you choose to concentrate on the question on partnership. It makes your revision easier. Right, so the aim of the session, or the aim of this short presentation, is to actually go through the key legal principles you need to think about based on the optional question that I gave to you last week. The first point you need to discuss is the actual definition of the word fiduciary. And this is in the context of actually dealing with ordinary partnerships where both parties or all parties under Section 1 of the Partnership Act 1890 work together with a view of making profit. So what do we mean by the word fiduciary? It simply means a duty of trust. So if you link that duty of trust to Section 1, which gives you the definition of an ordinary partnership, then it goes without saying that all partners owe each other a fiduciary duty. In simple terms, all parties owe each other a duty of good faith. In practice, all that means is that all partners will be working very hard to make the firm or business successful. All partners will be honest with each other, and all partners will bring to bear their skill, experience and expertise to make sure that the firm does make profit. So the word fiduciary simply means a duty of good faith, but in reality it means that using all your skill, energy and ability to make the firm profitable. Now, in relation to James, it's important that you refer to Section 28. And Section 28 is the first fiduciary duty owed to partners. And that simply states that all partners have to be honest and open about any financial dealings that they might have in relation to the firm or business. So in the case of law and law, it was to do with where one party kept or withheld vital information from the other partner and therefore got a good deal when they purchased shares belonging to that other partner. The key principle or key legal principle in law and law is that if your partners working together, then based on this particular case, you have to be honest and open, especially when it's to do with financial matters affecting the partnership. The next point to talk about, and that relates to Peter and John in the scenario given on the optional question, is Section 29. And again, Section 29 deals with another fiduciary duty owed to all partners. And that simply states that all partners must not make a secret profit. This simply means that if you in particular use the firm's business or you use the firm's assets for other business outside of the main firm's business, then you have to give to the firm any profits that you make. And this is clearly stated in the case of Bentley and Craven, which is available on Moodle or in any good business law textbook. But the point of Bentley and Craven is simply that if you make a secret profit outside of the business, just like happened in this case, then you must declare it and share it with the other partners. So under Section 29, you're not allowed to make a secret profit. If we move on to the last of the fiduciary duties under the Partnership Act 1890, and that relates to Section 30, and again relates to John. The key principle here is that you're not allowed to compete against the business. So this simply means that if you work for a particular firm or business, the law restricts you from setting up in competition. And as the next slide suggests, I'm going to move straight on to that. But before that, just a quick reminder that the case that relates to Section 30, not competing with the business, is Trimble and Goldberg in 1906. So the case of Trimble and Goldberg, 1906, clearly states that legal principle of not competing with the actual firm or business. Now the main point that links with Section 30, not competing with the firm or business, is to do with the contract in restraint of trade. And this particular point simply means that, generally speaking, most partners may be encouraged, and you might find this in the partnership deed, where you're encouraged to sign a contract in restraint of trade. Now, a contract in restraint of trade simply refers to where you're not allowed to set up a business within a specified geographical location for a particular number of years. And the specified geographical location, together with the time extent or limit, has to be reasonable. And a suitable case that explains contracts in restraint of trade, and I haven't noted it here, is the case of Nordenfelt and Maxim Nordenfelt, as in Nordfelt, Nordenfelt, V and Maxim Nordenfelt. I can't quite remember the year, but if you type that into Westlaw, or if you refer to your textbooks, the case of Nordenfelt and Maxim Nordenfelt will come up, and that explains contracts in restraint of trade. So if, for example, I work for a firm and I decide to leave the firm, I would have already have signed part of a clause or a contract which said that I'm not able to set up a business within 2 miles of the current business for 12 months, for example. If, for example, you have a restraint of trade clause which says you can't trade within, if you leave the firm, you can't set up a business for 50 years within a 1,000-mile radius, then both the time and the geographical extent are too excessive and therefore would be deemed by the courts to be unreasonable. So do remember the definition of a contract in restraint of trade. We move on to the next part of the optional question, and that's to do with dissolving a partnership. As stated when I looked at the compulsory question, there might be times when you set up a partnership at will, so the partnership carries on until agreed upon by the other parties to dissolve that particular partnership. There are times when you have a specified time period, so you might set up a partnership for 2 years to do a particular task or to achieve particular aims and objectives. So we're going to have a look now at the different ways in which you can dissolve partnership, and we have to refer to sections 32 and 33 of the Partnership Act 1890. So the relevance of those two sections, section 32 and 33, simply give details as to how you might bring to an end a partnership. There are two basic ways, and the first way is that you wouldn't have to bother going to court, and there are certain criteria that you might have to observe before you dissolve a partnership. And there are certain examples where you must use the court or seek the court's permission in order to end the partnership. So if we start off by having a look at the examples of where you can end the partnership without going to court. And it goes without saying that most partnerships are formed through an agreement. Most partnerships will have a partnership deed, and in the partnership deed it will clearly state that the partnership may come to an end through the unanimous agreement of all the partners. So that simply means that everybody's happy for the partnership to come to an end. There are times when the partnership might come to an end through effluxion, and that's to do with where you have a specified time limit. So in the partnership deed it will clearly state that the firm is set up for 5 years to build 10 houses, or the firm is set up for 10 years to trade in a particular product. So once the 10 years is up, or the 5 years is up, then the partnership comes to an end based on expiration of a fixed term. There is no need to go to court for either agreeing to end the partnership or through expiration of a fixed term. In addition to that, you wouldn't need to go to court if one of the partners becomes bankrupt. If one of the partners becomes bankrupt, then automatically the partnership ends. Again, normally it's always a good idea to have a partnership deed, because it's very likely that there will be provision in the partnership deed to clearly explain how the partnership might carry on in the face of one of its members or partners becoming bankrupt. The next point is illegality, and this point simply means that it's where one of the partners is unable to carry out their duties without it being illegal. A simple example would be a firm of partners who deal with driving, for example. So if you have a driving school and one of the partners loses their license, then for them to carry on the firm's business would mean that they have to carry it on illegally. A typical case is Hudgens, Yates and Cohen Watson in 1978, where a solicitor lost his practicing license. He couldn't carry on the business without it being illegal. So you wouldn't need to go to court to end the partnership based on the fact that one of the partners' continuance of the business would mean that it's illegal. And it goes without saying that death is a clear example of where the partnership would come to an end. So just if there's 6 partners and one partner dies, then it's very likely that the partnership will come to an end contrary to any provision in a partnership deed. We're now moving on to having a look at dissolving a partnership, but with the court's permission. A mental incapacity is the first example we need to have a look at. And again, if one of the partners due to illness becomes mentally incapable, then the clear point here is that the firm would have to go to court and seek the court's permission. And it's very obvious that the court will do what's in the best interest of the firm. Incapability is a slightly different point, and that relates to where a partner is unable to carry on their duties to an acceptable standard. So if, for example, you're a solicitor and you're no longer able to carry out your duties, not because you're ill, but simply because the standard you're supposed to apply is not good enough. That's to do with incapability, not being able to carry on your job successfully. The next and final point to do with seeking the court's permission is where it's just and equitable to end the partnership. And that's a bit of a vague point, but it simply means that there is no reason why the firm should carry on because things are just not working out. So in the case of Re-Energy Tobacco Company Limited in 1916, the main problem here was that the partners had fallen out so badly that they weren't even communicating or talking to each other. In that particular case, it is very evident that the courts will deem it to be just and equitable. In other words, it's fair, it's right to end the partnership, because if you link the situation where the partners are not talking to Section 1 of the Partnership Act 1890, then it's very clear that the partnership only survives if there is communication between the partners. The final point is just your conclusion in relation to fiduciary duties, clearly explaining what a fiduciary duty is or what the fiduciary duties are related to sections 28 to 30, and then move on to dissolving a partnership based on sections 32 and 33 of the Partnership Act. That's the end of the presentation, and may I take this opportunity to wish you all a wonderful and happy Easter, and we're back on Wednesday the 19th of April, and I shall be doing final revision towards the exam the week after. Thank you for watching this short video clip.